Do you guys all have an extra hour of additional knowledge to those that are not in attendance? Okay, there we go. Okay, so in that instance where an amendment is brought during proceedings, the Commissioner of Patents will stay the proceedings that are already before him. So the revocation proceedings allow for the patentee to make the amendments, and the Commissioner will then consider those amendments and deal with them as he deems fit, either to allow them or to refuse the amendment. And again, Section 5110 then provides the authority to the Commissioner of Patents to dismiss or override any amendment that may have previously been allowed.
Yes, Marco.
Yes.
Please, let's look at this. These amendments and corrections do not in any way affect the priority date of application, right?
No, not at all. No.
Okay.
It's solely to the contents of the specification and the claims, or to the application documents. But no, it's in no way affects the priority rights.
Okay, thanks.
And that brings us to the end of the amendments section. But then we'll have a look at the supplementary disclosure, which is provided for in terms of Section 51.8 and Regulation 52. And you'll recall we discussed patents of addition yesterday, where a patent of addition allows for the inclusion of any modification, improvement, or addition to an already filed patent. And with the patent of addition, you're actually issued a new official number. So it is a separate patent itself, although unassignable from the parent patent. A supplementary disclosure, on the other hand, allows for the addition of new matter to be added to an application, provided that it is fairly associated with what it is you have previously disclosed. So there must be a relation between this newly added matter and what has previously been disclosed. And you'll recall from the patent of addition, a patent of addition may be applied for at any time. So prior to grant as well as after to grant of the main patent. But a supplementary disclosure must be made before the acceptance of the application of the main invention. Okay, oh, sorry, before grant. If you look at Section 51, it says that the specification is framed and the acceptance of the specification has not yet been published. So that is before grant, not before acceptance. Sorry. Divisional applications need to be made before acceptance. Okay, so if we just have a look at what the Act actually says, it says that where an amendment may not be allowed by reason of the prohibition imposed by subsection 6A, which is that you cannot add new matter, but that new matter does in fact describe matter which may be fairly associated with the matter described in the specification as framed, and the acceptance of that application has not yet been published, then you can make application for a supplementary disclosure. The new matter may be introduced by way of a supplementary disclosure, and this is then just attached to the specification and dated with the date on which the application for the amendment was made for the supplementary disclosure. And so that new subject matter that is added is not able to benefit from the priority claim of the main invention. The priority date for that new matter is the date on which the application for the supplementary disclosure is made. Okay, so important to note that new matter now can't claim the benefit of the priority date of the patent application itself. And that's why the supplementary disclosure is dated, so that you can then determine the priority for that new subject matter that has been added. And unlike with a patent of addition, the supplementary disclosure isn't a separate patent or official number that's issued. It's just merely attached to the already filed application. Any questions regarding supplementary disclosures? No.
Marco, sorry
Yes.
to interrupt.
No, that's
Can
fine.
you maybe give us a practical example of where supplementary disclosure would fit in? I just looked at the 2001 exam, and I worked it out,
Mhm.
and I just thought it might be applicable where a preservative was added, so something like a preservative was added
Yeah.
for a product.
Yeah, look, in that instance where you've got a product and you're now adding something which will obviously improve uh, the life expectancy or the shelf life of that product, it would probably be considered that addition of the preservative would be considered to be fairly associated. I mean, it's not something that is separate from the invention. It's just new matter that is associated with what you have already claimed in the specification.
Okay, thank you.
Yeah. So that's correct. That will definitely be related to a supplementary disclosure because it's completely new matter. It's not a modification or improvement. It's something that wasn't previously disclosed in the specification itself. Yeah, then just the last slide on amendments and that you need to be aware of, particularly in practice, is if we consider the PCT application, so an internationally filed application, it is permissible to make amendments during the international phase. You'll recall yesterday that I discussed that there is an optional step of filing a request for a demand where you are lodging new claims and amending the claims that were filed in the international phase to overcome objections that were raised in the written opinion. And in terms of Section 43F of the Patents Act, it says that any amendment made during the international phase is deemed to be an allowed amendment in South Africa. Okay, so those amendments made during the international phase are already part of the South African application when it's filed in South Africa, when it enters the national phase. So you don't need to request the amendment to be made again. That amendment already forms part of the specification in South Africa. And that is in terms of Article 19 of the PCT and Article 34. So an Article 19 amendment is an amendment that's voluntarily made during the international phase. And an Article 34 amendment is an amendment made in response to a written opinion. Obviously, again, it cannot go beyond what was disclosed. So you cannot have new matter in those amendments. But just so that you do know that any amendment then in the international phase is deemed to be allowed in terms of Section 51. Then Section 52 also just gives the registrar the authority to make amendments as or as he deems necessary, in particular in respect of the register. Okay, are we happy with the corrections and amendments section? Great. Okay, I think let's take a quick 7-minute break, then we'll resume at 10 o'clock, if that's okay with everyone. So just to grab some water, and I'll see you then at 10 o'clock. Thanks.
Can we just do it ourselves then?
Hi, welcome back, everyone. We can then move along onto the rights in and to inventions and patents and who's entitled to the inventions or the application or the patent itself. So probably something that we should have had a look at before delving into the procedural aspects is who is actually entitled to apply for a patent application. And this is set out in section 27(1), which says that an application for patent in respect of an invention may be made by an inventor or any other person acquiring from the inventor the right to apply. So basically, it is either the inventor, if he has not assigned his rights or her rights to another party, alternatively, any person that has acquired the rights from the inventor to the invention is then entitled to make the application for the invention. Hi, Jed.
Can you just, I'm not sure about the others, but are you presenting?
Presentation. See. There we go.
Thank you.
Perfect, thanks. So how does this, if it is a third party, not the inventor making the application, how would you show that there has been this transfer of rights from the inventor to the third party, the assignee in this case? As we touched on it yesterday, it could be by way of a deed of assignment, where it's a contractual agreement between the two parties, the one being the inventor and the second being the assignee. Basically just setting out that the inventor has assigned his rights in the invention to the applicant or the assignee in that instance. It can also be by way of a contract of employment or any other agreement, such as a contract to do something. Contract of employment, you'll note that most contracts of employment do have the provision for the assignment of intellectual property rights should any invention or IP arise during the course and scope of their employees, employment to the employer, then those rights are automatically vested with the employer. That is also regulated in terms of common law, which was also affirmed in the Weather Service, King versus the Weather Services case. Although it was a copyright case, it would also be applicable to other forms of intellectual property, where the software that was devised during that during King's employment by the Weather Services was considered to have been the owner, or would have been considered the property of the Weather Services and not King, because it was related to the work that he would have ordinarily have conducted. So by operation of law in terms of common law, where there is an employer-employee relationship. Then a contract to do something, this is where you appoint a third party to possibly collaborate with you on the research that you're undertaking. They're not necessarily employee of yours, but they are contractually obliged to you to undergo and to perform certain services. that is not an automatic assignment where there's a contract to do something. So you always need to ensure that you have the rights transferred to you by way of either the contracts, including provision for the assignment of intellectual property rights, or by way of a deed of assignment. Then again, another example of an operation of law scenario would be where it's statutorily prescribed. So if you have a look at the Intellectual Property Rights from Publicly Funded Research and Development Act, there is provision there that the assignment for the IP does take effect if the research that was conducted was from a publicly funded research institution. Then also in the instance where the inventor has passed on, then the legal representative of the deceased inventor can make that application on behalf of the deceased person or the estate of the deceased. And this does happen quite regularly. And sadly, particularly, it was notable during COVID, where you would see an increase of inventors that had passed on. So the executor of that estate would then show that the estate had been wound up, or would provide some confirmation if it was intestate or testate that the rights had transferred to another party. So just remember that this does fall within the provisions of Regulation 28 that we looked at yesterday, and 29, in terms of the requirement that you need to show proof of the assignment of invention. And if the priority application was filed in a different party's name, that the rights have then transferred to the South African applicant as well. Andreas, you have a question?
Yes, thank you very much. I have not read your articles that you've sent us to as background information.
Yeah.
But I do see that in the question paper, there's this question about artificial intelligence, and what is it called? DABUS. Now, from what if I recall correctly, the inventor needs to be a natural person. It cannot be a juristic person. So how can a artificial intelligence then be a natural person? That does not gel. Those two are opposing concepts, I think.
No, that's a very good point that you've raised, and maybe something that we can discuss as a group as well. I'd like to get everyone's feedback on that and their thoughts on it. So for those of you that may not know, the South African Patent Office was the first patent office in the world to grant a patent for an invention that was devised by artificial intelligence, i.e. DABUS. And the creator of DABUS was Stephen Thaler, if I'm correct. No? Yes, I think I'm correct there. And they had listed the inventor as DABUS. And I think the citation that they placed on the application form was DABUS, an artificial intelligence, something along those lines. I can't recall the exact words, but they did specify that it was an artificial intelligence device that had been listed as the inventor. Unfortunately, the act is silent as to whether it must be a natural person or not. But I mean, it stands to reason that it should be a natural person, and that artificial intelligence just takes instructions. I don't think we're at that stage where it can automatically invent without some external input. But besides that, what do you think some of the issues would arise in this case, where the artificial intelligence is named as an inventor? What do you think the flaws are? My opinion is that the patent should not have been granted. It should have been refused, the application. But I'm very curious to hear your thoughts as to what some of the problems may be and why it should not have been granted. If you believe it should have been granted, I'm also very happy to hear your arguments on that. So please, I'm going to open the floor up. Let's discuss this. Come on, we can't be so quiet. Colin,
Can I go for it?
go for it.
You can't send it to prison if it does something unethical.
Yeah.
I don't know. It's pretty tough, but there's no. I think there's no repercussion. So if that AI bot tomorrow just doesn't exist anymore, then it opens you up for more problems than actually solutions, possibly.
Mm-hmm. No, it's a good point. I mean, who do you actually, enforce your rights against? You can't against artificial intelligence. You're going to drag the entire computer to court, you know?
And
Andre?
it will win, most probably.
Yeah, probably. Andre, you've got your hand up.
Yeah, good morning. Thanks, Marco. Yeah, that's basically also what I wanted to say. I was thinking on a practical sense, you can't take instructions from an AI.
Yeah.
If they are now your client, and they are, sued, I mean, that would be a very interesting litigation, because how can you take instructions from an AI?
Yes.
And
Exactly.
additionally, how can you institute proceedings on the basis of an AI? Not even talking about the AI paying your bills or whatever.
Fees,
I mean,
yeah.
you'd obviously have an issue with locus standi potentially as well.
Yeah. Look, I think to overcome that problem, it would have to be the founders of the artificial intelligence would probably have to, stand in legal proceedings. But I could be wrong. Neil, you also have some comments?
Yeah, thanks, Marco. Yeah, I think in my opinion, artificial intelligence is a tool used by inventors to create new inventions.
Yeah.
And to some extent, they are the ones providing the AI with the inputs it needs to generate the solution or an invention.
Yeah.
So in the end, it should be the person that's instructing the AI that should be cited as the inventor.
Yeah, that's my feel as well. I think that's the way that it should be addressed and dealt with. Laura, your comments?
Yeah, I agree with that as well. I feel like it undermines the whole purpose of intellectual property law and kind of prohibits the purpose of, encouraging research and development. And I also think it's a little bit awkward now, because I believe the USPTO and EIPO have also rejected the view, and they've kind of said inventors do need to be human.
Yeah.
And I think Australia initially accepted the application, and then it was appealed, and now they've also gone back on their decision. So there's a weird misalignment between South Africa and the rest of the world, and I don't think that's great for our system.
Yes. No, that's right. So you're correct. It's I don't know where Stephen Taylor's getting all this money from to I'm just going to put you on silent there, Ademi, for a moment. I don't know where he's getting the funding from to file these applications across the world and to go through all these lawsuits. But yeah, it's been rejected in every other country where he's applied for the application. But as you mentioned, Laura, in Australia, it was allowed, but it was then taken on appeal and refused. So he was unsuccessful in Australia as well. And everyone has held that it needs to be a natural person. And I think the EPO has also issued guidelines along those lines, that the inventor needs to be a natural person. What about some of the hurdles in terms of the South African application? What procedural things may have been overlooked in South Africa when the application was made? You need to bear in mind that South Africa's patent office doesn't conduct substantive search and examination. In terms of formalities, it also indicates that was this application actually examined for the formality requirements or not? The biggest issue, if we can look at it then, is obviously proving the entitlement issue, because I don't think, I can't recall if it was the inventor that was listed as the applicant or not. I don't think so. I think Stephen was listed as the applicant. Yeah. So how did they show this proof of Stephen's entitlement to the invention? There's no assignment document, there's no contract of employment, there's no contract to perform specific services. So that requirement wouldn't have been fulfilled. Furthermore, what about the declaration and power of attorney on the form P3? The P3 has a declaration in there stating that the applicant is entitled by virtue of an assignment or by operation of law or by employment. So you're sitting with a case where there's a false representation on the form P3. Although, if you do look at that form P3, the applicant merely crossed out that section in the declaration, which I also don't know whether that's permissible or not. And I don't think it is, because the regulations state that any substantial change to the forms has to be authorized by the registrar. So a lot of contentious points regarding that case. And it's quite unfortunate, because South Africa was being portrayed across the world as being this innovative patent office and allowing this progression to take place in the fraternity and to the public. But unfortunately, that wasn't really the case. It was a sad reflection that the application was actually granted, and highlighting the inadequacies that at that time stood at the patent office. But please, this is not an attack on me on the patent office at all. It is just the facts that happened at that time. Are there any other comments regarding Davis?
Just
Yeah.
I'm not I don't know. I've tried to, but I haven't been able to in this short time. I don't know what it is for, what the patent is about. But my experience with AI is it's about as intelligent as a well-trained 3-year-old. So it is good at seeing patterns, underlying patterns that might not have been immediately obvious to someone else. But it cannot, my understanding is, or my opinion, not understanding, my opinion is that it can't generate new knowledge. So it can't be inventive. It can see something that's not there, but if AI can see it, then someone skilled in the art would have been able to see it, and hence it would not be inventive.
Yeah, I don't know if I agree with that necessarily, Andreas. I mean, it goes back to that clip that we had from the movie yesterday, that although these things are pre-existing, certain features, integers in a claim may have existed separately, but that combination can still give you your novelty and your inventiveness.
Correct. So what would the counterpoint then be? The counterpoint would be that someone needed to instruct, and goes back to what you said earlier.
Yeah.
Someone needed to instruct the AI to say, solve this problem.
Yes.
And then the inventiveness or ingenuity would be in asking the question that needed to be solved.
Yeah. But again, that also correlates to an employer-employee relationship. the employer might highlight a specific problem and direct an inventor to go and conduct the research for them. But it's not the employer that's the inventor, it's the inventor that found the solution.
In that case, the employer, are you talking about the employer as in terms of the person giving the instruction?
Yes,
or
yes.
the employer as a juristic person? Because
no, as a person giving the instruction.
So what then prevents that person that gave the instruction to be an inventor?
Well, they should be prevented because there was no creation of their own from their own intellect. They just delegated the task.
Well, so then they could have done it themselves, and they asked the appropriate question.
Yeah.
Maybe they should be part of the inventor
yeah.
list.
Yeah.
Not a primary inventor if you want to make that distinction, but definitely a inventor.
Yeah.
But okay.
It's an interesting thought and topic, honestly. It's good to
just want to respond to Andreas, maybe just to support Marco. Even if it was the case where we wanted the employer to claim the invention, there should have been an assignment, which was missing. A point that Marco raised earlier.
Yeah. You see, so in terms of the formality requirements, just based on that basis, it shouldn't have been allowed because those requirements would not have been complied with. You wouldn't be able to show that there was a transfer of rights. And maybe that's something that can be looked at legislatively, is to possibly have, by operation of law, anything created by AI is then the owner of that AI's property. And I think that is the case with ChatGPT. Well, no, ChatGPT, I mean, that's another hot topic at the moment as well. I don't know if any of you have made use of ChatGPT or had a look at it, but, and it also goes, bless you, Andreas, it goes against what Andreas also said earlier, can it be new and inventive? But if you feed questions to ChatGPT, it's remarkable what type of responses you can actually get from it. And to be honest with you, when I was thinking about some exam questions, I thought, well, I'm curious to see what ChatGPT will provide as questions, and actually pretty good questions that arose from ChatGPT. Don't worry, I won't use those for the exam purposes.
I just want to add to that, and maybe it will help my colleagues here. I was trying to answer a past question paper, and I couldn't even understand the question. Okay, my lack of knowledge on the subject. But then I thought, let's use ChatGPT, and I copied the entire question, placed it into ChatGPT. It gave me all the answers that I was looking for, and it was a good tool for learning.
No, it really is. And I think it's quite groundbreaking, especially, for people that are conducting research, if they just cannot find, basis for what they're looking for, to try and use ChatGPT to get that information for them. Even if it's not something of substance, but at least as a guiding tool. So yeah, very, very remarkable where we're at the moment in terms of artificial intelligence. Yeah, I think, yes, another question there, or hand raised.
Yeah, sorry, Mark, I may have missed this. So what's the status now with South African patent that was granted, the one invented by AI? I mean, if the formalities were not met, shouldn't that be revoked or?
Yeah, look, so it is granted at the moment as it stands. Nobody has brought a revocation application. I mean, I don't think that there's anyone that's really too interested in revoking it, or the registrar needs to be taken on review. And all of these are going to be costly exercises. So it will depend on whether, there's a legitimate reason to do it or just to ignore it. I know that there have been talks in industry that a declaratory order be issued that the patent should not have been granted, but I don't think that has gone anywhere. But yeah, as it stands, it's a granted patent. I haven't checked if the renewal fees have been paid, but I'm sure that they have been paid, if any were due already.
Okay, somebody ought to do something about it if it's just gonna hang and
Yeah.
All right.
Look, I think it was. I think the purpose was more just as an exercise that the proprietor took to show that there is either deficiency in IP law or he wanted to prove a point. I really don't know.
Or maybe he himself was surprised it was granted, was expecting that it would be rejected.
I think, Andres, do you have the application number there with you?
No. Look at a good reference to the most recent article, but that relates to the Federal Circuit Court that holds that it's not valuable. And although they as far as I can see, they have a reference to reference number 6. But reference number 6 is just a reference to a UK court finding,
Okay.
but it doesn't go all the way back to
yeah.
Luke has put it in there for you.
Oh, great, thanks. We can have a quick look at the register. Sorry, I know that we're digressing, but it is something interesting to discuss. Right, so this is where you would search the registrar. Is it coming up on your screen there?
Yes,
you can see the CIPC website. So this is where you.
If it works.
Now the register is quite okay. So this will have the most recent details regarding the patent and whether the renewal fees have been paid and so on and so forth. So if you can have a look, you can see that the patentee was Stephen Taylor, but then Dabus under inventors was listed as Dabus. The invention was autonomously generated by an artificial intelligence. It has 2 priority claims, as you can see and then the title of the invention is a food container and devices and methods for attracting enhanced attention. Thanks, Laura. And then we can see the renewals. So if we have a look at the international filing date, remember the international filing date for a national phase application is deemed to be the effective date and the date from which renewals are due. So 3 years from then would mean that the first renewal fee would be due 17 September 2022. And as you can see from the history sheet, that the renewal fee was filed and that the patent is then still in force. So granted and in force. And again, it indicates that the next renewal fee falls due in September 2023. Any questions on that? I see you've got a hand there.
Sorry, Marco, I thought I'd just take advantage of, now that you mentioned renewal fees.
Yes.
If the international, wait, I'm just getting my thoughts straight. If you file a provisional application and then you go to a PCT, so that's your international filing date. If you do it in less than a year, so less than the 12 months, say maybe you still have 3 to 6 months to spare.
Yes.
Your renewal date will be the date that you filed the international date or the date that would have been the 12 months of.
No, it will always be the international filing dates.
So it would be yourself that would be cutting your time short.
Well, not really, because the renewal fee will always be due on the international filing date. But you're saying that
if you
yeah,
file sooner than you should have.
Yeah, look, it doesn't really make much of a difference because you're still paying for your 20 years eventually. And sometimes it might be worthwhile to obtain your granted patent as quickly as possible so that you can actually enforce the rights if there is an infringement.
All right, thanks.
Okay.
I was wondering password previously.
Okay. Interesting. The P3 is also available online. So I can show you what I was referring to as the clause that was struck out. That is a bit contentious. So that's what the P3 looks like, and you can see that this last section of the declaration to the P3 fails to include how the rights had actually transferred. That section was struck out. So it just says that the inventor is the person named above, which is Davis. And I don't even know if you can say Davis is a person. So just, yeah, interesting one. Now you can see what the P3 would look like. Okay. I was hoping to see if the specification was here, but it's not. I think whilst we've got the browser up, we can have a quick look at a specification, and we can actually pull up the exact specification of Davis. So I can see from the history that there were no amendments made to the specification. If an amendment was made, it would have been listed under the history sheet of the register page. So the South African specification that was filed would be an exact copy of the international specification. So yeah, you can see this is just the publication that takes place by PCT during the international phase, with the details of the international application, along with the publication drawings and the abstract relating to the application. Which, remember, this is from the international phase. But the South African application will mirror the same details of the international application. So if we go through the specification, you can see that it starts off with a title. As we mentioned yesterday, the specification must be preceded with a title. Then it gives a summary as to what the invention relates to, often gives a background to the invention, what deficiencies are there in the technical field, and what is the deficiency that this invention is trying to address. And then basically just the full description of what the invention is, how to manufacture it, what is used. So very much like a scientific document. Then also a description of each of the drawings, explaining what each drawing relates to, and then a description of the embodiment. So looking more closely as to what you are claiming as the features of the invention. So that's the full-on description. As you can see, they've even included some references as to citations in the specification. And then that is preceded with the set of claims. So this is what the court will turn to when assessing any litigation before the court, is to have a look at the claims and to see what the scope of protection is and the monopoly awarded to the patentee for the invention. So you can see there are multiple claims here. There's about 20 claims in total, yeah. And that is then followed by the drawings. So that's basically what most specifications look like. Jerry, I hope that helps to give a bit of a clearer picture as to what the documents look like.
Yeah, it does. Quick question.
Yes.
Can we access this document on the internet, or is it because you have some paid account with WIPO?
No, it's publicly available. I'll copy the link over and pop it into the group there. So all you require is, I mean, you can search with whatever details you want. You can search for, specific applicants. You can search for inventors. You can search using a title. But if you have the PCT number, then you can just search using the PCT number and it will take you directly to that publication.
Okay. And the search that we referred to as part of the application process, is this what we did now?
Sorry, can you repeat that?
The search and opinion that we get as part of the application process, is that more or less what we did while searching for a particular, when you make an application, there's a search and a report that comes back. Am I correct?
Yeah, so that's in the international phase. So that's also all published. I can show you under the documents tab at the end. You'll see there would be your written opinion. If there's no demand, then your written opinion automatically becomes your IPRP. But if there was a demand with amendments filed, you'll also be issued with your IPRP. And that will, you can have a look. That will set out the examiner's arguments and set out whether he finds novelty and inventiveness. So yeah, you can have a look at this in a bit more detail as well. And as you can see, yeah, he says that there's a lack of unity of invention. So he says claims 1 to 9 are directed to one invention, claims 10 to 20 appear to be directed to another invention. And this touches on the divisional applications that we discussed yesterday, where you would then file 2 separate applications or divide out the South African application into the main application or the parent and a divisional, where there's a unity of invention objection. And you can see he gives all the reasons as to why they believe that there is a problem there. Okay.
And the payment that we make for the PCT application, does it cover all this work that's being done? Or is it separate payment for?
Yeah, so it will include the initial search that's conducted. Yeah.
And the opinion that you wrote there?
Yes, yeah.
Okay. And then in the specification, the claims, they are numbered, right? And that's what we refer to as integers.
No, so integers are the features within the specific claim. Yeah, so
okay.
If I'm claiming this bottle as the invention, one integer would be the cap, one integer would be the thread on the bottleneck, and the third integer the bottle itself. Okay.
Okay.
So you're claiming the invention, but there's separate integers in that invention.
And those integers, are they numbered on the?
No, they're not. They're not numbered. No. So I mean, you can normally determine what an integer would be just by reading the claims and breaking it down into its separate integers, and that's what the courts would do.
But it's not listed as integers in the specification. One needs to.
No.
Okay. No. Okay. Thanks, Marco.
No problem.
And the link, please don't forget to post it here unless you have already done that. Oh, you've done
Sorry, the sound's quite bad, Jerry.
Yeah, I was referring to the link which you posted. Thanks.
No, I can't. Sorry, I can't hear.
Yeah, thanks for the link.
Okay, no problem at all. Okay. Any questions further questions before we carry on? Okay, I think we're good to continue then. Is the presentation up again there, Jerry? Andres? Yeah. Okay. So we've had a look at who should be able to apply for the application for the patent. But then in terms of Section 29, there is provision for instances where there are joint applicants. So the example that Adeyemi used is that there was a collaboration, for instance, between two universities, and both are entitled to the invention. You can file an application for a patent that lists more than one applicant. And what it says in Section 29 is that if there's no agreement to the contrary, the joint owners have equal undivided shares in the application. So if there's no contractual arrangement between those parties, it's believed that they own an equal and undivided share in the application. But I mean, there are times where it is regulated contractually, where one applicant may have expended more resources in developing the invention, and they might be entitled to a greater share. So this is just in instances where there is no agreement in place regarding the ownership of the application. But then Section 29 goes on further to say that none of them may deal in any way with the application except to save the application from becoming abandoned without the consent of the other joint applicant or applicants. So each applicant has to consent to any action that is taken regarding an application. So if, for instance, they have a buyer that is interested in purchasing a share of the invention and the application, they can't undergo that assignment without the consent of the other party. The only exception is to maintain the life of the application and to ensure that it doesn't lapse. And that's, for instance, the payment of renewal fees or other actions used in order to maintain the pendency of the application. Laura's asked a question if there's any case law in South Africa I know of which speaks to joint inventorship. This isn't necessarily in terms of joint inventorship, it's joint ownership. There should be case law on this, but I can't recall it off the top of my head. But I will make a note of it, Laura, and have a look and then get back to you on those cases. But there is certainly cases where this is dealt with. Yeah, then Section 29, subsection 2 goes on to whether, when a dispute arises between the applicants, how those disputes should be addressed with. So you'll see that disputes are addressed with in various sections within the Patents Act, but all looking at different stages of the life. So it will either be a dispute between the ownership of the invention or the ownership of the application, and then also ownership of the patent, all having very, very similar provisions. But it says that any dispute regarding the rights and the way that the application should be dealt with must be addressed to the Court of the Commissioner of Patents. So the Commissioner will hear any dispute. So it falls outside of the ambit or the jurisdiction of the registrar and has to be dealt with by the Commissioner of Patents in the Court of the Commissioner of Patents. Then it just says that the person bringing the application will be liable for those costs and expenses. Then what remedies are available is, should a dispute arise as to the ownership in and to the application, it says that the commissioner may order that the rights to any joint application be assigned, provided that where it appears to the commissioner to be just and equitable, he may order the payment of compensation to the assignor. So in that instance where there is joint ownership of the application, the commissioner can order that one party assign their share in and to the application to the other party, provided that they are justly compensated. And as with the other instances where a dispute does arise, the commissioner should always try and address these matters in a way that they can preserve the application and to see it through to grant. So to avoid an application from lapsing. So as you can see from section 29, subsection 4, unless good reasons to the contrary, the commissioner is to resolve a dispute in a manner which will lead to the preservation of the application and the grant of the patent. Then section 28 again arises or touches on topics where there's a dispute between the ownership, again relating to the invention. Very, very similar provisions as to what we've just looked at. So if we just briefly run through those, section 28(1) says that where a dispute arises between persons as to their rights to obtain a patent for or to make, use, exercise, or dispose of an invention, or as to the right or title in a patent, any such party may apply to the commissioner to decide the matter in dispute, and the commissioner shall then decide on the matter in dispute. So this is basically in instances where an application hasn't been filed, but there is an invention that exists. So where there's an ownership dispute regarding the ownership of the invention itself prior to an application being filed. Then if the commissioner is satisfied that a person not being obliged thereto is unable or unwilling to exercise his rights, he can again order that that person executes an assignment, and again, compensation must be awarded. But because these rights are territorial in nature, he can then extend that assignment to include the right to file for applications for the invention in other jurisdictions, just to ensure that that party that is aggrieved and who then becomes the assignee is entitled to file for applications across the world. Again, sections 49(1), 2, and 4, again says, now looking at granted patents, says that if there's an agreement to the contrary, again, the rights in and to that patent are held in equal and undivided shares amongst the co-owners of the patent. In this instance, however, the rights of the patentees differ in that any joint patentee may institute proceedings for infringement. So it's not necessary that both patentees bring an infringement action. It can only be one of the patentees that is entitled to bring an infringement application or action. However, the other party obviously needs to be notified of the intention that the first co-patentee wishes to institute infringement proceedings, and they are then obviously welcome to join in those proceedings as a co-plaintiff so that they can also recover damages. If they don't join as a co-plaintiff, then only the party that brought the infringement action will be entitled to damages awarded. Okay. Then it again goes on to the rights of the patentees, saying that they cannot deal with a patent in any way except for the infringement actions. without the consent of the other. So they cannot exercise the rights to the patent without the consent of all patentees. They can't license it, they can't assign it without either party's consent. And then again, Section 49 goes on to once more look at the way that disputes regarding the ownership of the patent are dealt with. Again, I'm not going to go through this. This is basically a copy and paste of the previous sections that we have looked at in terms of Section 28. So you can work through that in your own time. Any questions regarding disputes and ownership of patents and inventions and applications? Okay. It seems we're good to carry on then, looking at the assignment of applications. So Section 59 provides that the rights vested in a patentee or an applicant for patent shall be capable of assignment or devolution by operation of law. So it can be transferred as a hereditary asset, for instance, and that the patentee or an applicant is able to assign an application for a patent to a third party or assign a granted patent to a third party. Interestingly, those assignments of an application or a patent have to be in writing, but we'll look at that in the next section. But subsection 2 of Section 59 then touches on provisions that are excluded from employment contracts or clauses that will be deemed to be null and void in employment contracts. So any condition in a contract of employment which requires an employee to assign to his employer an invention made by him otherwise than within the course and scope of his employer. So a provision in a contract of employment that requires the employee to sign any invention over to them which falls outside the course and scope of their employment shall be deemed to be null and void. So it's not permissible to do that. Then the second exclusion is where the employer restricts the rights of an employee in an invention made by him more than 1 year after the termination of the contract of employment. So this relates more to a restraint of trade. You cannot force an ex-employee to assign rights in an invention to the ex-employer if it was created more than a year after the employment was terminated with the employer. Okay, jumping back to assignments. As I said, an assignment agreement has to be in writing. It cannot be a verbal assignment. There must be proof that the assignment has taken place as an immovable property, that being the patent or the application being transferred from the present patentee to a third party. It has to be in writing. It is advisable for the assignment of the patent or the assignment of the application to be recorded in the patent register. And that is because if it's not recorded, then that assignment is not valid to third parties, to the public. It's only valid between the parties that are agreement thereto. So you need to record it in order to have proof that it is a notification to the third parties and the public that the rights have transferred to the third party. And in terms of the legislation of the regulations, the assignment should be recorded within 6 months of the effective date of the assignment. So if party A sells the assignment to party B, that assignment should be recorded within 6 months of it taking effect. It is possible to do it after the 6 months has expired, but you then need to request condonation, which is basically just paying a late fee for the late recordation of the assignment. And I mean, this happens on a daily basis where, you know, patents are sold from one company to another, or even where companies merge. You know, company A merges with company B, and their assets have then been transferred to company B by virtue of the merger of those two companies, and those should then all be recorded. In any event, if they were ever to institute proceedings in court and they were not recorded as the proprietors of the application or the patent, they would first have to be recorded as such on the register before they can proceed with the proceedings. And as I said at the beginning yesterday, you know, you must always remember that intellectual property is an asset that it can be dealt with in the same way you would a tangible asset. And therefore, these rights to patents can be attached. And then those should also be recorded on the patent register. And then hypothecation is where you would offer it up as security for a debt in that instance. So exactly as I said with a tangible asset, where you would offer it up as security for a debt incurred. All of which should be recorded in the patent register. It's not mandatory, but it is advisable to do so. Any questions regarding the previous section we've discussed on assignments? Jerry?
So what is the impact when it's not recorded in the patent register?
What is the tax?
So,
So what's the fee?
no, what is the impact if the assignment is not registered in the patents register? It's you mentioned it's between the parties. Doesn't affect the public.
Yeah, so as soon as there's any dealing that has to take place where you are instituting proceedings against a third party, so if there is an infringement of those patent rights, you can't institute those proceedings for infringement until that assignment has been recorded, until the registrar is updated with the details of the correct proprietors of the patent.
Oh, I see.
That's
I see what you mean. Yeah.
Because you know
So-
you need to give notice to the public.
So in this case, the original inventor might still be able to enforce, but the second one might not be able to.
Well, look, it's not the inventor, it would be the owner. So
The owner, yeah.
yeah. Well,
In cooperation with the owner.
yeah,
I mean,
that's correct.
yeah.
Yeah.
Okay.
Yeah, on my side, I'm trying to understand the hypothecation.
Okay.
It's not very clear.
So it's very seldomly used in practice. But what a hypothec basically is if you take a loan from a bank, for instance, you know, the bank wants to be sure that they will get their money back from you. And in return, in order for them to provide you with that loan, you would offer up your asset, in this case being a patent, as security for that debt. And that's what the hypothecation is. It is basically you are securing it against a debt that you are taking.
All right.
Okay. And that then brings us to the end of that section. We will now turn to licenses in terms of compulsory licenses that may be awarded for a patent. So there are two instances where a compulsory license can be awarded by the Commissioner of Patents. And the first is that where there is an abuse of rights of the patent, and secondly, where it relates to a dependent patent. So Section 56 deals with a dependent or a compulsory license where an abuse of rights over the patent is occurring. And if we work through this together, if we have a look at Section 56, it says any interested person who can show that the rights in the patent are being abused may apply to the Commissioner in the prescribed manner for compulsory license under the patent. So this would occur in instances where a party does wish to obtain a license to use a patent, but that the patentee is unwilling to license it, and they would then turn to the court for a remedy in the form of a compulsory license, where the patentee is forced to grant a license to the third party. And subsection 2 of 56 then sets out what would be considered an abuse of rights and what the courts would need to look at in determining whether an abuse of the rights of the patent have occurred. So the first is that the patented invention is not being worked in the Republic on a commercial scale or to an adequate extent after the expiry of a period of 4 years subsequent to the date of the application, or 3 years subsequent to the date of the grant of the patent, whichever period last expires. And there is, in the opinion of the Commissioner, no satisfactory reason for no such working. So in terms of South African law, some countries require that the patent has to be worked in order to maintain the life of that patent, but South Africa doesn't have that requirement. However, if the patent is not being worked to an adequate extent on a commercial scale in South Africa, then the Commissioner can grant that a compulsory license be issued. Then if we look at subsection 2C, it says that the demand for the patented article in the Republic is not being met to an adequate extent on reasonable terms. So the demand of the public cannot be met by the working of the patent itself. So in that instance, there is working within South Africa of the patent, but the demand just cannot be maintained or kept up with, where there's a greater demand for what is being supplied in terms of the patented invention. We then move on to the next consideration as an abuse of right. It says that by reason of the refusal of the patentee to grant a license or licenses upon reasonable terms. So in this case, there was some engagement with the patentee for a license, but he's refusing it. And the refusal of awarding that license, the trade or industry or agriculture in South Africa, or any person or class of persons or establishment of a new trade or industry in the Republic is being prejudiced, and it's in the public interest that a license or licenses should be granted. So this is where there is a prejudice to public interest. I mean, if you think of the COVID pandemic, this would probably have been a very good provision to rely on in terms of an abuse of right, where it was in public interest that the vaccine should have been made available. But even, you know, it could have been an instance where the demand for the COVID vaccine wasn't being met, where a compulsory license could have been granted to a third party. So it's a very good example to consider the COVID pandemic and how these provisions could have applied in that instance. And then the last point that would be considered an abuse of right is that the demand in South Africa for the patented article is being met by importation, and the price being charged by the patentee or his licensee or the agent of that patent in South Africa is excessive in relation to what's being charged in other countries. Okay, so where the demand itself is being met for the invention, but it is being met in terms of importation, and that the price is also then excessive. That will also be considered an abuse of the patent rights. So very, very important considerations that the court needs to have a look at, and also for examination purposes, quite a nice topic to discuss. Are there any questions on the points that are considered an abuse of right? Interestingly, no compulsory license has ever been granted in South Africa. The provisions are there, but I mean, it is quite onerous to prove that an abuse of rights has actually taken place. Perhaps it's not to say that there hasn't been consideration for compulsory licenses. It could also be that parties have, you know, agreed to settle these disputes out of court and enter into a voluntary license as opposed to a compulsory license. So it's not to say that the provisions don't work. Perhaps the threat of it does actually force people to enter into voluntary licenses as opposed to going to the Commission of Patents for the award of a compulsory license.
Yeah, Marco, sorry. Will you be able to give us any case relating to this, even if it's outside of South Africa?
I'll need to have a look for you for a case. Yeah. There was one case in South Africa that did deal with it. I just don't have the citation with me, but I will pull it up.
All right.
I think it was Nexa, the case possibly with Nexa, that dealt with, you know, which is the National Energy Corporation of South Africa. There might be a case relating to compulsory license there, but I'll look it up for you and get back to you. Laura, do you have a question or comment?
Hi, Marco. I'm just wondering, is there any interaction between this section and competition law or, I don't know, standards exercised by the competition commissioner?
No, not that I'm aware of, because I mean, this is completely not necessarily separate, but it's upon the Commission of Patents to decide on this. There's no nothing that alludes to the Competition Commission in this instance. And these are it's an exhaustive list as what would be considered an abuse of rights. So you know, whether it's anti-competitive behavior, I think you could possibly turn to the Competition Commission, but I don't think you will have much success in that instance, specifically because there are provisions for it in the Act, and that the jurisdiction to deal with it is by the Commission of Patents.
Okay, thank you.
Yeah. Look, unfortunately, these instances don't arise very often, so I guess practically there's not much information to base it on as well. Andre, did you have a comment? No.
Hi, Marco. Yeah, thanks. It's just it's actually a very small question, although if there's no case law on it, I don't know whether we would have the answer. But so the section refers to an interested person or any interested person.
Yeah.
It seems like a very low standard for locus standi. It seems like people could potentially try to be opportunistic. I don't know if they'll be able to get it right, but is that essentially what Section 56 requires? Is any interested person? Is that requirement so wide in your interpretation?
Yeah, look, I think that they would have to show that they would be able to. I mean, if the demand's not being met in the Republic, I think that they would have to show an interest and that they would possibly be able to then meet that demand, that they have the manufacturing capabilities. So yeah, it does seem quite broad, but I don't think it's as broad as what you are thinking it to be. No.
No, okay, thanks. That makes sense.
Yeah.
Maybe if there's a case, we'll know. But
We'll know. Yeah.
No, that makes sense. Thanks.
Yeah. Okay, if we then move. Hi.
Can you hear me?
Yes, Jerry.
Wouldn't this be more applicable in cases like vaccines that are very crucial for protecting life and monopoly is restricting access?
So Jerry, sorry, I'm really struggling to hear you there.
Is that better?
Yes, slightly better.
Isn't this more applicable in cases where, for instance, vaccines that are not reaching the public and purely because of the monopoly?
Yeah, so that's right. And that's why I was saying that, these probably would have been very good provisions to rely on in terms of getting compulsory licenses for the vaccines where it is in the public interest. But there is also provision, and I'll touch on these later on in the section, where the government does have the right to acquire the rights to the patent should there be a need for them to do so. And that was, but we'll discuss this. We'll discuss this when we get to that section. Yeah, because it's also an interesting one to debate. Okay, so if we then look at the remainder of Section 56, it just says that the patentee or any other person appearing from the register to be interested in the patent may, in the prescribed manner, oppose the application. So it just says that the patentee or the licensee can then oppose an application for compulsory license. Then it goes on in subsection 4 to state that the commissioner shall consider the application on its merits and may order the grant to the applicant of a license on such conditions as he or she may deem fit, including a condition precluding the licensee from importing into the Republic any patented articles. So this just provides the commissioner with the power to authorize and to grant a compulsory license. Then if the commissioner is of the opinion that an order directing the grant of the license is not justified, he may refuse the application. Quite self-explanatory. License granted under this section shall include a provision subject to adequate protection of the legitimate interests of the licensee. The licensee shall, on an application by the patentee, be terminated if the circumstances which led to the grant cease to exist and, in the opinion of the commissioner, are unlikely to recur. So if what led to the grant of the compulsory license, the abuse that occurred, no longer exists, then the compulsory license should be uplifted. Then further on, it says that any license granted under this section shall be non-exclusive and shall not be transferable except to persons to whom the business or part of the business in the connection with which the rights under the license were exercised has been transferred. And in determining the conditions on which the license is granted, the commissioner shall have regard to any relevant facts, including the risks to be undertaken by the licensee, the research and development undertaken by the patentee, and the terms and conditions usually stipulated in license agreements in respect of subject matter relating to that type of invention, between persons who would ordinarily enter into voluntary license agreements. So basically giving the commissioner guidance as to what he needs to look at when considering the grant of a compulsory license. Then the commissioner may order that a license granted in terms of this section shall be deemed to have been granted on the date on which the application was received by the registrar. Any order of the commissioner under this section shall be made with a view to avoiding the abuse found by the commissioner to have been established. And the commissioner may amend or revoke any license granted under this section. All quite self-explanatory, and just going into the powers of the commissioner and the considerations he needs to take into account. Subject to the conditions that may be attached to the license, a licensee under this section shall have the same rights and obligations as any other licensee under a patent. The commissioner may, when ordering the grant of a license, award costs against the applicant or patentee concerned or any person opposing the relevant application. Again, you can just read into that yourselves. Yeah, nothing much more to be said under this section then. So that covers the first instance where a compulsory license can be awarded, and that is where an abuse of rights of the patent has occurred. The second instance, which I mentioned, is where there is a dependent patent situation. And this arises when the working of somebody else's patent cannot be worked without them infringing a pre-existing patent. So if we have a look at section 55, it gives an explanation as to what a dependent patent is. And it says that where the working of a patent, hereinafter referred to as a dependent patent, without infringement of a prior patent, is dependent upon the obtaining of a license under that prior patent, the proprietor of the dependent patent may, if agreement cannot be reached as to such license with the proprietor of the prior patent, apply to the commissioner for a license under the prior patent, and the commissioner may then grant such a license on such conditions as he may impose, but including a condition that such license shall be used only for the purpose of permitting the dependent patent to be worked and for no other purpose. So quite a mouthful, but it basically allows for one patentee that's separate from another patentee to be able to use their patent in order for the other patentee's patent to be worked. So they cannot perform their invention without infringing on a pre-existing patent. Let's think of a smartphone as an example, where in order for Apple to make use of their phone, so they've patented their Apple iPhone, but they need to use an Intel processor. The processor is owned by, the patented technology is owned by Intel in respect of the processor, but Apple needs to make use of that processor in order for their phone to work. So had they not had the consent from Intel to use the processor, they would otherwise have infringed on those rights in respect of the processor. And this is a typical scenario where a dependent patent would come to play, and the grant of a dependent patent in that instance. Is everyone on the same page as to what a dependent patent is? Hi, Andres.
Hi, thank you. Yes, thank you very much for the explanation. It's clear. I'm guessing that this hasn't been used in reality either.
No,
because it would also be a deterrent in the same way, and that it's highly likely that there will be some kind of a outside of court settlement to make the agreement.
Exactly. And I think it acts as a deterrent because people are aware that their hands can be forced by the courts should they not be obliging to considering the grant of a license. And I mean, there's so much various technologies in one item that are patented and possibly by different patent holders, that you would run into situations like this. I once heard a joke that they said that the iPhone is not actually an iPhone because they have licensed so much of Samsung's patents in order to run their iPhone. Whether it's true or not, I don't know, but that does happen. Okay, but then Section 55 tells us that the commissioner shall not grant a license unless the invention claimed in the dependent patent involves an important technical advance of considerable economic significance in relation to the invention claimed in the prior patent. So this is basically what the commissioner needs to consider in order to grant a dependent patent. But as you can see, I mean, quite subjective, because what is considered an important technical advance, what is considerable economic significance, might be difficult to prove these in court. Then also the proprietor of the dependent patent granted the proprietor of the prior patent on reasonable terms a cross license to use the invention claimed in the dependent patent. So there has to be a cross license afforded in the instance where a compulsory license is granted for dependent patent so that they can use each other's technologies. The use authorized in respect of the prior patent is obviously not assignable except with the assignment of the dependent patents. And licenses, these sections that I've highlighted here are just things that you can look at in your own time. Again, not something that I'm going to go into much detail in. Just bear in mind that voluntary licenses should also be recorded in the patent register. Because if a licensee is not recorded in the patent register, they can't bring actions for infringement proceedings, and they also can't join as co-plaintiff in infringement proceedings. So it is advisable that if there is a voluntary license, that license should also be recorded in the patent register. And the same timelines as assignments would also be applicable. So you should record a license agreement within 6 months of the dates affecting the license agreement. Then Section 90 is also relevant to license agreements per se in terms of drafting and relevant to those in commercial practices, just conditions that are excluded from contracts relating to licensed patents, and what you should bear in mind if you do ever draft license agreements for patents, what would be considered to be null and void. So Section 91 says that any condition in a contract relating to the sale of a patented article or to a license under a patent of which the effect will be to prohibit or restrict the purchaser or licensee from purchasing or using any article or class of articles, whether patented or not, supplied or owned by any person other than the seller or licensor or his nominee. So a license agreement cannot restrict the licensee from purchasing items that do not form part of the patent from third parties. You can also not prohibit or restrict the licensee from using any article or process not protected by the patent, quite self-explanatory. Also not able to require the purchaser or licensee to acquire from the seller, licensor, or his nominee any article or class of articles not protected by the patent, very closely tied with subsection A there. You're also not allowed to specify a minimum resale price in the license agreement. And then lastly, you also cannot restrict somebody from using the invention where it is not patented. So if we look at that, it says you cannot prohibit or restrict the making, using, exercising, or disposing of the invention concerned in any country in which the invention is not patented. So if it was a South African patent, you can't prohibit the licensee from exercising that invention in Botswana, for instance, if there is no patent there. So it is still territorial in nature. Okay, then furthermore, in terms of section 92, it states that nothing in this section shall affect any condition in a contract whereby a person is prohibited from selling any goods other than those goods of a particular person, or affect any condition in a contract for the lease of or a license to use a patented article whereby the lessor or licensor reserves to himself or his nominee the right to supply such new parts of the patented article. So you cannot force somebody to make use of their spare parts if you can obtain it elsewhere. And that then brings us to the end of licenses. I see that it is 11:30. There's not, we should be busy for between another hour and 2. So my suggestion is that we break for half an hour, come back and then resume the final sectors of the workshop. Otherwise, we can continue for a little bit and take an hour lunch. It's up to you whether you wish to get done earlier or later today. I'm happy with any suggestions. So my proposal is that we break for half an hour and then resume for the last bit of work and call it a day. Otherwise, we can take an hour's lunch later on and continue after that.
I agree. Let's break now.
Okay.
Yeah, that's fine.
Okay. Perfect. So let's break for half an hour. We'll resume at 12 o'clock then, and then hopefully by 2 o'clock we should be done with today's workshop. Perfect. Thanks, Luke. I'll see you all in half an hour then. Thank you. Welcome back, everyone. I believe we can resume. It seems as if most of the participants have rejoined our session. The next chapter we'll be looking at is the restoration of a lapsed patent. This basically focuses on an instance where the patent has lapsed due to the non-payment of the renewal fees, what the requirements are in order to be successful for the patent to be restored in the instance where the renewal fees were not paid, what the limited rights are of the patentee should an order be granted to restore the patent, and also just having a look at the procedural steps that that take place. Golofelo, I don't understand what you've posted. You have a question? Ah, thank you. Yes, the recording is on. Thank you.
Sorry, that was I was busy editing.
No, that's fine.
I pressed send by mistake.
No problem.
Thank you. All right.
Thanks. Okay, so we are recording. And these provisions are dealt with in section 47 and 48 of the Patents Act. So should a renewal fee not be paid when it is due or within the applicable grace period that's permissible, which is ordinarily 6 months from the due date of the renewal fee, the patent is deemed to have lapsed. And in those instances, it is possible to restore the patent had it lapsed because the renewal fees were not paid. But two requirements have to be met, and that is that the lapsing of the patent must have been an unintentional lapsing. So it must have been an unintentional omission from the patentee not to pay the renewal fee. And then also there must be no undue delay in bringing an application for the restoration of the patent. So if we have a look at section 47(1) and 2, where a patent has lapsed owing to non-payment of any prescribed renewal fee within the prescribed period or extended period referred to in section 46(2), the patentee may in the prescribed manner and on payments of the prescribed fee apply to the registrar for the restoration of the payment. So this is basically just stating that the patentee is able to apply for the restoration of the patent if the renewal fees were not paid by the times that they were due. However, the patent can only be restored if the registrar is satisfied that the omission was unintentional and that no undue delay occurred in the making of the application for the restoration of the patent. Once the application is made and the registrar receives the application, he then needs to advertise the application in the patent journal for an opposition period. As you would have seen, we have for post-grant amendments, an opposition period is also applicable to the restoration of a patent. So if there is no opposition to restore the patent, the registrar will then issue an order restoring the restoration of the patent, or if he deems fit, he will dismiss the application if he feels that the requirements of no undue delay in bringing the application or that the omission was intentional in not paying the renewal fee, then he can dismiss the restoration application. However, where opposition is given, similarly with an amendment opposition for post-grant amendment, the opposition needs to be referred to the Commissioner of Patents. So it moves again away from the powers of the registrar, but to the powers of the Commissioner of Patents. So once more, the High Court judge that is appointed as to sit as the Commissioner of Patents. So as you can see from subsection 47(4), it says where notice of opposition is given, the Commissioner shall, after hearing the applicant and the objector, decide the matter, and the Commissioner will then either restore or dismiss the application for the restoration of the patent. In order for it to be effective, the patentee has to pay all renewal fees which he had failed to pay previously. So just to recap on section 47, we now know that you can only apply for the restoration after the 6-month grace period, because that is when the patent would have lapsed. Otherwise, it's only deemed to have been provisionally lapsed in that period where the grace period, the 6-month grace period exists. And we also know that you need to apply for the restoration of the patent in the prescribed manner, as you can see from the first subsection of section 47(1). Says in the prescribed manner, you need to apply for the restoration. What the prescribed manner is dealt with by regulations 49 to 51. And these regulations provide that the application to restore the patent is made as an ex parte application to the registrar in the form as near as possible to a notice of motion in terms of the Uniform Rules of Court. And this is then obviously accompanied by one or more affidavits setting out the facts. So the patentee would need to attest as to the reasons why the patent had lapsed. They would need to aver as to why it was an unintentional lapsing of the patent. And they also need to submit this application within reasonable time in order to fulfill the second requirement for the patent to be restored. And this does happen quite regularly in practice, where often in practice there are renewal agencies that tend to the renewal payments of patents. And it could be that their systems are docketed incorrectly. The incorrect date may have been input into their systems and the renewal fees lapsed. So you would need to then obtain affidavits from the relevant persons as to why the renewal fee was not paid in support of the request to restore the patent. Again, we've touched on what the two requirements are. Just that the omission must have been unintentional and that no undue delay must have occurred in bringing the application. Again, we have touched on all of this, but just to recap, so if the registrar is satisfied with the application, it's then published in the Patent Journal for opposition purposes. If there's no opposition, he will either issue an order restoring or dismissing the application. But if there is opposition, it is moved to the Commission of Patents to then hear the parties and decide on the matter of whether to restore or not to restore the patent. Quite straightforward provisions. Any questions regarding the restoration of a patent? Hi, Jerry, I'll let you go first.
Yeah, just out of interest, what is the renewal fee? Does anyone know?
So the renewal fee differs depending on the year when it's due. So if it's the first renewal fee that's due, I believe it's 90 or 100 Rand. I can pull it up.
Okay.
For you. It's not a lot of money. It's not a lot. No. And it ranges between 100, 150, 210 Rand, depending on which year is due for payment. Andres, you also had a question?
Yes, it's not regarding the restoration as much as it is about lapsing of the patent. Is the lapse of the patent then published by the registrar?
So ideally the register page, so you know the page that we looked at earlier from CIPC's website, that
Correct.
should indicate the status of the patent as lapsed due to the non-payment of renewal fees. And they've become quite good at updating it. So I often do come across cases where it is updated on the register.
Okay.
Yeah.
So, and the reason for my question is the next part.
Yeah.
We'll then circle back. Okay.
Okay.
Thank you.
No problem. So section 48 then looks at the limited rights of the patentee once the patent is restored. Because obviously in that period where the patent has lapsed, a third party may have expended money in manufacturing the patented invention, which they're authorized to do because the patent has lapsed. There are no enforceable rights during that period. Or they could have started importing the product into the country or started selling the patented product that's subject to the patent that has lapsed. So obviously those rights of the patentee are then limited. And this is set out in section 48, which says that the patentee of a patent that has been restored in terms of section 47 shall not be able to institute any proceedings against or recover damages from a person who infringed the patent after the lapse of the patent and until the date of the application for restoration being published in the patent journal. So in that period, should anyone have infringed the patent, had it been enforced still, the patentee is not able to institute infringement proceedings or recover any damages from that third party. It also says that you cannot institute proceedings or recover damages from any person who used, offered to dispose of, or disposed of any article made or imported in the same period as we just mentioned. So between the time of the lapsing of the patent and the publication of the application for restoration in the patent journal. But it then becomes even worse for the patentee in terms of his rights being limited to quite an extent, is that during that patent had a third party commenced using or exercising the invention to which the lapsed patent relates, or who continues to use or exercise the invention, or uses or offers to dispose of any articles produced during that period where the patent had lapsed, the patentee is not able to institute proceedings against that third party. So quite severe consequences for the patentee if the patent has lapsed and somebody continues or has continued to exercise the rights over the invention during that period that it lapsed and continues to do so. They are actually permitted to do so without any consequences against him by the patentee. It seems a bit unfair towards the patentee, but I guess if somebody has set up a shop, set up factory manufacturing facilities, it would also be considered unfair to them because in their mind, they were rightfully entitled to continue exercising rights over the patented invention. Section 48, subsection 2, then goes on to say that where the patent has been restored, any person who during the period, again, during the period where the patent had lapsed, has expended any money, time, or labor with the view of making, using, exercising, offering to dispose of, disposing of, or importing the invention, may apply to the commissioner for compensation in respect of the money, time, and labor so expended. So again, quite a harsh consequence that can be brought against the patentee, as a third party can then retrieve costs for the money, or not cost, damages for any money, time, or labor that was expended during the lapsing of the patent. And then subsection 3 just says that the commissioner needs to make an assessment as what amount of the compensation is that should be granted to the third party. Important sections. This is something that comes up every year in the exam, so please do take a look at this. It is Also something that arises in practice quite often, and very important to note, especially for those that are dealing with litigation of patents. Any questions regarding the restoration of a patent? Hi, yes, Andres.
Yes, so this was the reason for my previous question,
Yes.
because it's not as if that person was diligent in reading the patent journal and then saw, hey, wait a minute, this one has lapsed. Oh,
Yeah.
goody for me. And this person would have needed to put some reminder, some flag somewhere to tell him or her, listen, check whether this renewal is paid. If it's not paid, let's
Yeah.
use and abuse.
Interestingly, on your
yes.
point, sorry, a person is able to lodge at the patent office what is referred to as a caveat. So it's a specific application form that is then lodged to the registrar, and that is basically a request for the patent office to notify that party of any action that arises on a specific application or patent. So the onus is then on the patent office to notify that party. So if it is something of, great significance and great value, and there is a competitor, they might actually consider lodging that caveat so that if something does go awry with the patent, they can jump in and take over.
Yeah, so my point being that the person isn't really such an angel as the as the right to claim damages signify, because they would have wanted to make use of the patent and then deliberately started.
No, exactly.
It wasn't
That's why
just,
I feel it is quite severe, and the consequences are quite harsh for the patentee, unfortunately. Yep. Any other comments or questions? Yeah, so that brings us to the end of that chapter, and we'll now look at revocation. So this is where the validity of the patent is attacked on one of the grounds that's prescribed in the Patents Act. So any third party is able to apply to the Commissioner of Patents to bring an application for the revocation of the patent, where it is basically struck off from the register. So this is set out in terms of section 61. Again, a very important section to take note of, especially for examination purposes, something that does crop up quite regularly in the exams. And the grounds are quite clear-cut. It is set out in section 61, and it was confirmed in the case of Busby that it is an exhaustive list, so nothing can be read into the legislation as an additional ground for the revocation of a patent. It's only what is prescribed in terms of section 61 that is an acceptable ground on which to revoke the patent. So as you can see, section 61 says that any person may at any time apply in the prescribed manner for the revocation of a patent on any of the following grounds. Yeah, you can see the locus standi is quite broad because you don't need to show any particular interest. Unlike with where there is an abuse of right, where any person may apply, but there must be an interested party. Yeah, it is just any third party can apply for the revocation of the patent. Again, the application for the revocation may be brought at any time after the grant of the patent, up until the expiry thereof, and even after the fact. I have already touched on those topics. Just also important to note is that you can rely on more than one ground, as you would recall from our discussions yesterday regarding novelty and inventiveness. You can bring an attack on multiple grounds regarding the validity of the patent. And then often, as arises in infringement proceedings, if the patentee brings an infringement proceeding against a third party, it often happens that the defendant will then counterclaim for the revocation of the patent and rely on the grounds provided for in Section 61. So their defense would basically be, while the patent is invalid, I'm not infringing, and they wish to revoke the patent on either of the grounds that we'll have a look at now. So the first ground on which the patent can be revoked is that the patentee is not a person entitled under Section 27 to apply for the patent. So you'll recall that we mentioned who is entitled to apply for the patent. It's inventor, any predecessor entitled, an heir, for instance. So if it's not a person that was entitled to the patent, then you can revoke the patent on that ground. Then if we look at B, it says that the grant of the patent is in the fraud of the rights of the applicants or of any person under or through whom he claims, so that there was a fraudulent activity in obtaining the rights in the patent. And this is often assessed where it's construed that the conduct of the applicant's part deliberately was designed to deprive the person that's bringing these proceedings to whom the rights were actually vested in, either as the true inventor or the true assignee, so that there was some underhanded fraudulent activity. Then looking at the next provision, this is that the invention concerned is not patentable under Section 25. So you'll recall that Section 25, a very important section that we went through to quite some extent yesterday, dealt with the novelty, dealt with inventiveness, dealt with method of treatments, dealt with biological processes, and the other exclusions from patentability. So the invention is related to a discovery, or the invention is related to a mathematical method or scientific theory. You can then attack the patent on any one of those grounds, in that it's not patentable in terms of Section 25.
Marco?
Yes.
Will this be applicable to that grant relating to the AI we were discussing the other time, the one granted earlier and was later challenged?
So for Davis, look, you could possibly rely on the first provision, that the patentee is not the person entitled, so that Stephen wasn't entitled because he's unable to show a transfer of rights should the AI have rights. So that could be the one. C itself relates to the invention. So the subject matter itself regarding Davis might be valid. So I don't think this provision would necessarily apply because it looks specifically at the subject matter of the invention and not so much as to the inefficiency or inadequacies in the application and the entitlement to the invention. So I think A would probably be more appropriate.
Okay, thanks.
Okay. Then if we turn to the next ground, it's that the invention as illustrated or exemplified in the complete specification cannot be performed or does not lead to the results and advantages set out in the complete specification. And this is what we refer to in practice as the inutility provision. So it relates specifically to the description and not necessarily the claims of the invention, because the description as illustrated or exemplified within the description of the specification doesn't lead to the results. You cannot actually work the invention. You cannot perform the invention because the description and the drawings don't illustrate how to obtain the results, doesn't provide a clear indication as to how to perform the invention. So it's when it's deficient in the teaching the specification and description then doesn't teach somebody that's skilled in the art to be able to perform the invention. And it's also something to bear in mind in practice for those that do draft patent specifications to, you know, steer clear of making claims within the specification that, you know, the invention is guaranteed to produce X results. Rather steer clear of that, because if somebody cannot obtain those results that you have alleged, then it is also a basis on which to revoke the patent. Then if we look at E, the complete specification concerned does not sufficiently describe, ascertain, and where necessary, illustrate or exemplify the invention and the manner in which it is to be performed in order to enable the invention to be carried out by persons skilled in the art. And this is what we refer to as insufficiency. And this is basically a question of fact as to whether a person skilled in the art, upon reading the specification, has the proper instructions to enable him to put it into use. So quite closely tied to the previous provision, D. Hi, Andres.
Originally, the requirement was to disclose the best method, and that was amended, I think, in 2000. I fell into that trap during our international discussion. Any idea why they would have let go of the best
method
in favor of just a sufficient description?
Yeah, I don't know the answer to that, to be honest with you. Sorry, that was before my time still. I think it is still relied upon in some other jurisdictions where you have to set out the best method. But yeah, no, I don't know the reason to that. Burrells might have the answer. Burrells tends to assess old legislation and new legislation and give a comparison. So I'll have a look into it. Yeah.
Okay, thank you.
Okay. Then the next provision is that the claims of the complete specification concerned are not clear or fairly based on matter disclosed in the specification. And remember that these are two of the three requirements of the claims. The one is that the claims must relate to a single invention, but as you can see, it's not a ground of revocation if the claim does have more than one invention. But it is a ground of revocation if it's not clear what the claimed subject matter is. So you're very vague in what it is that you're claiming, and also that it's not fairly based on the description within the specification. So again, a subjective test, which people do also tend to rely on quite commonly in practice. You know, in my argument in terms of a unity of invention objection is that it could be, in my mind, unclear as to what the claimed invention is if you're claiming more than one invention. Because what is the scope of protection actually then that the patentee is after? What is it that they're seeking to protect? And there could be an argument that that might be a clarity issue, but it hasn't been tested in the courts yet. Then another important provision that is often relied upon and probably is also relevant, Adiemi, to the Davis patent for the artificial intelligence is that the declaration lodged in respect of the application for the patent or the statement lodged in terms of section 33A contains a false statement or representation which is material and which the patentee knew or ought reasonably have known to be false at the time when the statement or the representation was made. And in this case, this provision was also amended. It previously used to be that the patentee knew, but it was then introduced that the patentee ought reasonably to have known as well. So became a more onerous requirement that the patentee should have known that the representation is a material misrepresentation. You know, and a material misrepresentation is any misrepresentation of fact, which, if acted on by the registrar, would result in the applicant obtaining something to which they are not entitled. You know, and some elements that may lead to a misrepresentation on the Form P3 would be the incorrect citation of the inventors, the applicants not acquiring the rights to apply, attesting to the fact that there's no lawful grounds for the revocation, that the incorrect priority details are contained on the Form P3. And that was the subject of this case of Benz Limited and another in South African, Leadworks, because the Form P3 says that the priority details that are stipulated in the P3 is the first application in respect of that invention. And you'll recall yesterday that I spoke about those continuation applications in America, where they file application upon application and continuously claim various priorities, where it falls outside the 12-month period within which to claim valid priority. That's what this case dealt with. And they held that there was a material misrepresentation, and the patent was revoked on that basis, that the priority claim was incorrect. Then also, it's not just relating to the Form P3, the declaration and power of attorney, but it also relates to the Form P26, which is the statement that the invention does or does not relate to indigenous biological or genetic resources from South Africa. So if that declaration is incorrect, then the patent can also be revoked on that ground. Then if we move on to the next ground on which the patent can be revoked, it's that the application for the patent should have been refused in terms of Section 36. That is, that the invention is frivolous on the ground that it claims an invention which is obviously contrary to natural laws, that encourages offensive or immoral behavior, or the requirements in terms of the nuclear energy provisions haven't been complied with. Then another provision, which I think is a bit of a harsh one, is that where the complete specification, which relates to a microbiological process or its product, doesn't comply with Section 32(6), which is that you need to provide the accession number or details of the microbiological deposit at the facility that stores that microbiological deposit. And those are the only grounds on which a patent can be revoked. Quite a long list, but as I mentioned, quite an important one to know. Are there any questions so far? Okay, if we then move on again, you recall with our discussions from earlier and also the divisional applications that South Africa doesn't object to a unity of invention issue where the claims relate to more than one invention. And it expressly says in Section 62 that a patent grant should be granted for one invention only, but that no person may in any proceedings object to a patent on the ground that it comprises of more than one invention. So it's a bit of a dichotomy, because on the one hand, it says that you can only obtain a patent for one invention, but on the other hand, nothing can be done if it contains more than one invention in the claims. In the instance where the patent is revoked on the basis of the fraud of rights, then instead of revoking the patent, what the commissioner can do is that he can ensure that the rights to the patent are then transferred to the rightful owner. So as you can see, in section 63. It states that where a patent is revoked on the ground of fraud, or a patent fraudulently obtained has been surrendered and revoked, the commissioner may, on the application of the inventor of the relevant invention or his assignee, so whoever was the rightful party to the invention, the commissioner may then direct the grant of the patent to that person. And then section 64 just deals with voluntary surrenders of a patent, which isn't required for the purposes of this exam. So you can have a look at that in your own time. And that then brings us to the end of the revocation chapter. Are there any questions on the previous sections? Yeah. That then brings us to the last section of the work. We will have a look at infringement. The last two chapters itself are for self-study, so I won't be going through those with you today. And those are the chapters on appeals to the commissioner and the court, and also offences and penalties in relation to misuse of the words of the patent office, alleging that you're a patent attorney, but you're not, or an employee of the patent office when you're not, all quite self-explanatory. So those last two chapters, you can go through those in your own time and work through it from there. So we'll then move on to infringement. But before we delve into infringement, it's not a very lengthy chapter. It's quite straightforward. We need to understand what the rights are of the patentee once the patent is granted. And you'll recall that I mentioned yesterday that the grant of a patent is a negative right because it affords to the patentee the right to exclude others from performing certain acts. So if we see section 45, it says that the effect of the patent shall be to grant to the patentee in the Republic. So again, it's a territorial right, subject to the provisions of this act for the duration of the patent, which is 20 years, the right to exclude other persons from making, using, exercising, disposing, or offering to dispose of, or importing the invention, so that he or she shall have and enjoy the whole profit and advantage accruing by reason of the invention. So those provisions that the patentee is entitled to exclude others from conducting would be considered your acts of infringement. So should any other person manufacture the patented article, should they use it without the consent of the patentee, should they advertise or sell such products, import the invention, then they would be committing an act of infringement. You can have a look at the definitions of each of these acts in more detail. I have given some definitions. It's just the dictionary definitions from, I believe, the Oxford Dictionary as to what each of those terms mean, and the broader picture as to what would be considered an act of infringement. Then it goes on further to say that the disposal of a patented article by or on behalf of a patentee or his licensee shall, subject to other patent rights, give the purchaser the right to use, offer to dispose of, and to dispose of that article. And this is basically your provision relating to the exhaustion of patent rights, where once that patented article has been disposed by the patentee, his rights in respect of that article are exhausted, and the owner of that patented article then can do with it as they deem fit. Okay, then who has locus standi to bring an application for the infringement of the patent? It's obviously the patentee itself, so the person that is entitled to the patent. The licensee themselves has no independent rights to bring an application for infringement. However, the patentee must give notice to every licensee recorded in the patent, who are then able to intervene as a co-plaintiff. So, should there be an instance where the patentee feels that his rights to the patent or in and to the patent are being infringed, or bring an infringement application to the court, and the test that the court will apply in assessing whether an infringement has taken place was set out nicely in the Ensign Bickford case. And you'll recall that the Ensign Bickford case also looked at inventiveness. So we did touch on this case yesterday, where they set out the test for determining inventiveness, and they also looked at how you would determine whether there is an infringement of the patent. So in order to determine if there is an infringement, the court would first have to decide whether the alleged act to have been performed is actually an act of infringement. So would it form part of one of these acts that would be considered an act of infringement? If so, then they'll continue with the investigation and they'll construe the claims to determine whether the alleged infringement falls within the scope of any of the claims. So yeah, the claims will again be broken down into their integers, and then a comparison will be made between the patented invention with the alleged infringing article. And if the alleged infringing article contains all the integers from the granted patent, then there will be an infringement found. But the court then also needs to decide whether the defendant has a valid defense. And this is probably where the defendant will bring an application for the revocation of the patent on one of the grounds that it is invalid, either because it lacks novelty or inventiveness. But essentially, it's then just a comparison of the claims of the specification with those of the alleged infringing article. Both gentlemen look a bit confused.
Nope.
No, good.
I'm just thinking. Yeah, I'm just thinking, do companies or defendants, as the case might be, go about trying to exploit weaknesses in patents so that they can also make money? Is that what happens in the real world?
Yeah, definitely, it happens. And oftentimes competitors will see how can they design around the patent itself. What can they do that differs from the patent in order to avoid a possible infringement. Colin, did you have something to say?
No, I was just saying I was confused as well, but I wasn't. You can't see me, so.
Okay. Okay, so it is quite a straightforward assessment in terms of comparing what is claimed and comparing that to the alleged infringing article. But again, you've got to be, as a patent drafter, you have to be very careful in terms of your choice of words, what your intention is in terms of the words that you're using, and to be clear as to what it is that you're actually claiming, so that you can avoid a situation where the courts are not uncertain as to what it is the invention relates to and what the scope of the protection is that you're seeking to afford. And the way that the courts interpret these claims has evolved. It does differ from Commission of Patents to Commission of Patents, depending on who's appointed, as to how they go about interpreting the claims. There's a very literal approach often taken where a word in the claim is given its ordinary dictionary meaning, or the courts will see what was the intention of the patentee in the specific words that they had chosen, and that's more considered to be your purpose of construction of the claims. But you can look at that in your own time if you're interested in seeing how courts actually go into the nitty-gritty of interpreting the claims. Anil.
Yes, thanks, Marco. When you mentioned the construing of the claims, you just mentioned integers. I assume those would be essential integers, so they would actually inquire whether the integers form an essential part of what is being claimed. And
Yeah, so ordinarily it will start off with a literal interpretation. Again, it depends on the judge, from judgment to judgment. But in the purpose of construction of the claims, which seems to be the more favored approach, is that the courts will assess what is considered to be the essential integers, and make an assessment of integers that are irrelevant, and then only focus on the essential integers, as you mentioned.
Okay.
Yeah.
Marco?
Yes.
Just out of interest, the balance between, or the striking of balance between the claim too wide and risking a revocation, and making it too narrow and risking the ability to monopolize the patent. As a patent attorney, is it quite stressful?
Yeah,
Because
it is.
you
Look,
could lose
I myself am not a spec drafter, and I'm very glad that I'm not. It's not something that I enjoy doing. But it is incredibly stressful, and especially dealing with inventors and gathering information, and having to consider the prior art, because that's how you would determine how wide your scope of monopoly is or how narrow it is by determining what is already out there. But definitely quite a stressful exercise, and especially trying to find the right words to use and ensuring that, you teach the invention in such a way that there is utility, that it is a sufficient and enabling disclosure. So definitely a very, very tricky exercise.
Thank you.
Adeyemi?
Thank you. I want to look at this item 1. Said decides if the act alleged to have been done by the defendant is of such a nature that could constitute an infringement of a patent. I'm trying to look at it and trying to create a picture. To what extent can such be deemed fit to have infringed? What extent are we going to?
Yes.
Yeah.
Continue.
Yeah, something. I think you understand my question already.
Yeah. Well, they would just need to assess whether what this alleged infringer is doing falls within the ambit of the exclusions that third parties are excluded from performing over that invention. So, are they producing the invention? Are they actually marketing that invention without consent? So it solely relates to what acts are considered an act of infringement. So is what that third party, that alleged infringer, doing, does it fall within these acts of infringement, within these exclusions?
Thank you.
Okay. If we're just going back in terms of the description as well, the interpretation of the claims. The South African courts have also held that when interpreting the claims, they should look at the specification as a whole. So they need to see what the specification teaches, what is the teaching of that's set out in the description when interpreting the claims, because the drafter of the claims might attach a specific meaning to a specific word, and define that word within the description. And there's a lot of jargon that's also used within different technologies. So to ensure that the court gives the correct interpretation to a specific word within the claim or specific integer, they need to consider how it's defined within the description when determining the meaning of what is being claimed. Okay, then if we just have a look at section 67, which is presumptions that are made in relation to new substances. I feel that I've missed a section. Just give me one moment, sorry. Okay, yeah, still fine. So it says that a claim in respect of a patent for a process or an apparatus for producing any product shall be construed as extending to such product when produced by the process or the apparatus claim. So essentially, if the claim is directed towards the process of manufacture or the process of producing a specific product, then the patent protection, the monopoly, also extends to the product manufactured by that process. Okay. So even though you haven't claimed the product itself, but you have claimed the process of how it's manufactured, then it's deemed that the patent also extends to the product that's manufactured by that process. Then subsection 2 states that if the invention for which a patent is granted is a process for obtaining a new product, the same product produced by a person other than the proprietor of the patent or licensee, unless proven to the contrary, is believed to have been obtained by that process. So if a third party is manufacturing the same product of your patent, which claims the manufacturing and the processing of that product, then it's deemed that that third party's article was obtained using the same process or method of manufacture. And it's up to them to show otherwise, that the product was derived from a different process or manufacturing process. Then lastly, it just says that that person is not required to disclose any trade secrets if it is unreasonable for them to be expected to do so. Then just for interest's sake, it was held in this Grand Parois versus Sasol case that contributory infringement of a patent does form part of South African law, although it's not expressly provided for in the Patents Act. It is deemed to a delict, and therefore the requirements of a delict must be complied with in order for somebody to brought to the books for contributory infringement. Just what are some of the defenses that are brought? Obviously, the most common is that there isn't an infringement of the patent for various reasons, or that the patent is invalid. And this is where the defendant will then apply for the revocation of the patent on the basis that it is invalid in a counterclaim in response to the infringement. Then also leave and license. This is where the defense is usually based on the alleged grant of a license. So there's a purported license that was granted to an alleged infringer, or they are of the view that they had a tacit license awarded to them. And then also the exhaustion of rights, which we know is permitted in terms of subsection 2 of section 45. Just so that you know, the ignorance of the existence of a patent is no defense, as is the same with any law. Ignorance to the law is no defense. So what remedies are available to the patentee should there be an infringement of the patent? Well, the first is an interdict to prevent a third party from their continuance of infringing the patent. Then there's also the delivery up of any infringing product or article or product of which the infringing product forms an inseparable part. So this is where any infringing articles of the patented invention need to be delivered up for destruction to the patentee. And even if it forms part of a greater unit, that greater unit then also needs to be delivered up. Then the patentee is also able to pray for damages, to be awarded a cost, a damages reward. Then section 65 subsection 6 goes on further to say that in lieu of damages, the plaintiff may, at his or her own discretion, or, you know, in their prayers, be awarded an amount calculated on the basis of a reasonable royalty, would there have been a license. So they can ask for determination, for the court to make a determination as to what would have been due to them had a license been granted to the infringer. So if there was a hypothetical license between the parties, then they can ask the court to make an assessment as to what royalties would have been due to the patentee should there had been a license agreement in place, and then for those royalties to be paid to the patentee. And then obviously in your prayers for infringement, it's important to request for the costs of the action. Relatively straightforward. If we then look at partial validity in terms of a patent having some claims that are valid and some claims that are invalid, this is dealt with by section 68. And yeah, it says that where in proceedings for infringement of a patent, the commissioner finds that any claim in the complete specification in respect of which infringement is alleged is valid, but that any other claim therein is invalid. So as I said, basically where a patent has at least one valid claim and one invalid claim, then the following provisions apply. And that is, if there is a counterclaim for the revocation of the patent on the grounds of invalidity, the commissioner may then stay the proceedings and issue or direct the patentee to effect an amendment to overcome the alleged invalidity. And should the patentee amend to overcome the invalidity, then the commissioner may order costs as he deems fit, taking into account the relief. So if we just have a look at the wording, so it says that when a specification has been amended in terms of paragraph A, so where there is a counterclaim for the revocation of the patent and the patentee amends the claims to overcome that invalidity, then the commissioner may grant relief in respect of any claim which had before the amendment been found to be valid and infringed. and in exercising his discretion, he may take into account the conduct of the patentee in inserting those claims which had been found invalid. So the court will only award damages in respect of the claims that were valid and not those that were invalid in the infringement proceedings. But the court will also consider the conduct of the patentee when making that assessment as to damages. And conduct being possibly that the patentee was aware that there was an invalidity in the patent. So the patentee knew of prior art, for instance, that destroyed the novelty of one of the claims, or prior art that led to questions around inventiveness of some of the claims, then that will be construed as not being the best conduct on the part of the patentee, and the courts will take that conduct into consideration and likely in favor towards the alleged infringer. Yeah, declarations as to non-infringement. This is something that I'll leave for self-study. You can have a look at section 69 in your own time. One of the exclusions from infringement is set out in section 69's uppercase A. This is where an act which would ordinarily have been an act of infringement is excusable. And this is what's commonly referred to as the BOLAR provision. And the conduct that is excused from infringement is where regulatory approval is required to enter the market of the products. And this is specifically applicable to generic pharmaceuticals, so that they are able to obtain market approval to sell the generic pharmaceutical as soon as the patent expires. So that there is, taking into account the delays in obtaining the necessary approvals for generic pharmaceuticals. And that's what this provision basically relates to. So if we have a look at it, it says it shall not be an act of infringement of a patent to make, use, exercise, offer to dispose of, or import the patented invention on a non-commercial scale and solely for the purposes reasonably related to obtaining development and submission of information required under any law that regulates the manufacture, production, distribution, use, or sale of any product. Okay, so as I said, mostly applicable to generic pharmaceuticals. So the manufacturer of the generic pharmaceutical is able to obtain whatever regulatory approval is required for them to enter the market as soon as the patent expires. So it doesn't create delays in terms of the pharmaceutical or the generic pharmaceutical entering the shelves, entering the marketplace. I'd be interested to know, what is your take on pharmaceutical patents? Do you think that pharmaceutical companies exploit patent rights? Do you think it's against public interest for patents to be awarded for pharmaceuticals? What are your thoughts? Hi, Andreas, go for it.
Well, I think that there's a lot of money in having a good, patentable and sellable product, but in order to get to that one, let's use a common word that is used in a different aspect. To get that unicorn, you have to go through a lot of horses. because there's a lot of horses around that looks like unicorns until you decide that they are not the unicorn. And whether I think that a different regulatory route needs to be applied to making undue profit. But as far as the protection of that invention, that compound is concerned, that pharmaceutical method, I think that it is fair to protect it, simply because research is expensive, research is risky, and you need to protect the whole value stream. And then if there is an abuse, I mean, by all means, then say that there's abuse of rights, and that they're making $500 profit, whereas they might as well have made $40 worth of profit. So that I think should be dealt with commercially and not in terms of IP.
Yeah, no, it's a very good point to make. Any other views?
I know in Australia that the synthetic drug kind of what is craze or whatever that ran a couple of years ago, and it's still going on, where they basically just add a simple compound or something to a molecule and they repatent it. And that for me kind of shows not really a proper approach to research, in a sense, and actually finding out what that molecule does. And also, it's not like, for me, it's not novel enough almost. It's just adding something onto a product and going, cool, great stuff, we've got a new molecule now.
Look, I mean, in that instance, it might have novelty, but inventiveness might be debatable. And you know, that's exactly what the government of India steers clear from, is what they refer to as evergreening, is where that, you know, slight adjustments in a certain pharmaceutical just extends the life of that product, you know, the patent life of that product, by filing new applications for improvements to it. So yeah, if you are interested, you can read up on evergreening. Diemi, you also have comments.
Yeah, I think that comes to what you explained to us on the aspect of inventiveness and the innovation. So I think the more it goes into innovation, the more it becomes a process that can be registered. So I will agree that it depends on what process of the production we're addressing here.
Yeah, it's true. But you know, it is costly to bring these attacks on the patents every time as well, in terms of whether it's novel and inventive. You know, but it is of public concern that access to medicine has become, you know, incredibly difficult and very expensive. The thing is, it's unfortunate, as Schalk mentions, you know, these things should possibly be addressed with differently, and not on the grounds of intellectual property being the baddie. You know, there's a lot of people that campaign against patent rights, you know, the Treatment Action Campaign being one of them. But I feel that there's not much understanding as to how the patent system works. You know, if you consider if no patent rights were granted for pharmaceuticals, then what incentive is there for pharmaceutical manufacturers to actually continue doing what they're doing? You know, and I mean, that is one of the purposes of the patent system, is to incentivize research and to gain some commercial success from patents. Interestingly, there was a study conducted that showed, in terms of pharmaceuticals, there's so many regulatory hurdles that they have to go through, so they can't enter the marketplace, necessarily from the date of grant of the patent, because they need to go through their medical trials. They need to obtain the necessary approvals from the regulatory council, such as the FDA or the Medicines Controls Regulator in South Africa. So that all eats into the lifespan of the patent, where that monopoly is then eroded away because of additional requirements. Interestingly, though, some countries, their patent legislation actually permits for an extension of the term of a patent, where you can get a supplementary extension of the term, specifically for cases like that where the monopoly has been eroded away due to these stringent requirements in obtaining regulatory approval. South Africa doesn't have such a provision, though, but there are some countries where you can apply for a supplementary extension of the patent term, so that they are still able to benefit from the monopoly that they otherwise would have had they not been a pharmaceutical invention. And the study that I was referring to actually showed that some of the pharmaceutical companies only start profiting from their patented invention within the 16th year. So prior to that, it would have taken about 16 years for them to recover the costs that they expended in developing that drug. So essentially they're only getting 4 years worth of profits. Yeah. Food for thought. Okay. Any other comments that somebody might have? You're welcome to oppose the views. Okay.
Sorry.
Yes.
I guess I do agree with everything you guys said, except that I suppose it just leaves a bad taste in the mouth, when, say, people are dying and yet you have governments or pharma holding on to patents, as we've seen recently. But I suppose, as Andrea said, there has to be some sort of a balance. It may not be, not looking at it from the IP side, but from the commercial side. But there has to be some sort of a balance, some sweet spot that can be reached, because it just leaves a bad taste in the mouth.
But the thing is, there is provisions for government to acquire the patent rights. And this is actually what I mentioned to Jerry that I was going to discuss earlier, but I don't have it in the slides. But if you look at one of the articles that I submitted to everyone, I looked at those specific provisions that the government has, and I looked at it in relation to when the COVID pandemic was at its height, and what remedies were available to them. And there is remedies available to them. So it was very mind-boggling for me as to why South Africa and India were, looking at TRIPS waivers and all of that, when there were actually provisions available to them to exploit these means. Yes, compensation needs to be made, an agreement must be reached between the parties. But even if the government and that party cannot come to an agreement, the commissioner, the court of the commissioner can decide on what is just and equitable. So, I don't know if government's not aware that these provisions are available to them or not. It's just interesting to me.
I mean,
you can look at Section 78. Section 78, I have it here. It says that the minister may, on behalf of the state, acquire on such terms and conditions may be agreed upon any invention or patent. So it doesn't even necessarily have to be in public interest. And even if they don't want to rely on those provisions, they can request a compulsory license in terms of an abuse of rights, where the demand isn't being met.
But why would they want to fork out that cost,
Yeah, that's the case. But that's what was strange for me was that they were looking at overcoming hurdles in terms of TRIPS waivers, when the TRIPS waiver is already there, and there are already provisions in the Act that does give them some kind of exploitation over inventions. Even if you look at Section 4, it says that the state is bound by a patent, but then it goes on further to say that provided that a minister of state may use an invention for public purposes on such conditions as may be agreed upon with the patentee, or in default of agreement on such conditions as determined by the commissioner on application. So again, the state is able to either acquire the rights or to either obtain the use of those rights.
Are
Marco,
we- sorry.
Rita,
Yes.
continue.
I just wanted, maybe mixing issues here. Those provisions that you read, would those now be applied to patents that are already granted in South Africa, presuming either via Paris Convention or national fees, or were these maybe that were not available in South Africa yet?
Yeah, okay, I understand your point. That is a good point. Section 4 specifically relates to a patent already granted. So it could be that, those rights weren't yet granted in South Africa. I'm not too sure about Section 78, though. Let me quickly check. Yeah, you see, Section 78 says that the state can acquire an invention or a patent. So it's not just in respect of a patent, it's for the invention itself. So even if it's not patented yet.
Maybe that was the difficulty. But with government, you never know.
Yeah. Andre, I saw you wanted to say something.
No, Marco, thanks. Yeah, I think everything I wanted to say was covered. So it's definitely very interesting.
Okay, perfect. Thanks. Andreas, did you have any further comments?
Well, yes, I just wanted to say it's a mix of hindsight and foresight. It might be that government had enough foresight to know that no one would want the vaccine, and hence, in hindsight, we can say that it was smart to delay and not spend too much money because people there wasn't that much of an uptake of the vaccine. So not having the vaccine was not that much of a problem because no one wanted
it. Yeah, I guess that is an argument. Okay. Yeah, very, very interesting topics, and I enjoy that we can have these conversations and debates. So if we then move on, let me just pull my notes up quickly. Just something to be aware of as well in practices, and this is probably going to be the last slide that we'll be discussing, is in instances where an applicant or patentee makes an unjustified threat of infringement against a third party, that they can run into some troubled waters, because that aggrieved party who's receiving this unjustified threat can then request that the commissioner issue a declaration that those threats are unjustifiable. They can also obtain an interdict against the patentee to stop making such allegations and such threats. And that person, the aggrieved party, can also recover damages that he has sustained due to unjustified threats. So if we have a look at Section 71, it relates to the remedy for groundless threats of infringement proceedings. As I mentioned, it says that where any person by circular, advertisement, or otherwise threatens any other person with proceedings for the infringement of a patent, a person aggrieved thereby may, whether the person making the threats is or is not entitled to or interested in a patent or an application for a patent, institute proceedings against him and obtain a declaration to the effect that such threats are unjustified, an interdict against the continuance of such threats, and you may also recover damages if any threats are sustained, unless the person making the threats proves that the acts in respect of which the proceedings are threatened constitutes, or if done, would constitute an infringement of a patent in respect of a claim in the specification, which is not shown by the plaintiff to be invalid. So just something to bear in mind in practice, you know, especially in terms of South African inventors and South African applicants, they are incredibly enthusiastic about their inventions. They are incredibly guarded by their intellectual property, and oftentimes feel that, you know, any slight resemblance of their invention is an infringement of their rights. So sometimes you just need to either calm your client down and not just proceed with a threat of infringement, which is often the case, is that your client will want to know what action they can take. You know, they'll want you to send some letter of demand and want you to allege that you will institute infringement proceedings, you know, as a scare tactic. But the patentee can run into troubled waters if he's unsuccessful, should he go ahead with infringement proceedings, and it's found that that person is not actually infringing. So definitely something to be mindful of. The best way to approach this, where, you know, your client is concerned that there might be an infringement taking place, is simply by bringing the other party's attention to the existence of the patent. You know, so sending a letter of demand stating that, you know, Mr. Vata is the patentee of South African patent number 2022 12345, which relates to a vaccine for COVID, and the specification of the patent is attached with the letter. In that way, you place them on terms, and you know, if you are successful, you can then recover damages from the date of the letter of demand sent, from the date of that letter where you have proof that the patentee was notified of the not the patentee, where the alleged infringer was notified of the existence of the patent. On that note as well, it is also something to consider when advising your clients to ensure that an article of manufacture does bear the South African patent number on it, you know, because that also serves as notification of the existence of the patent, and will also establish from when damages may be recovered in terms of an infringement proceeding. And that's all I have for everyone. I hope that these 2 days together have been insightful, that it's been useful, and will hopefully create some foundation for those that wish to pursue intellectual property, and especially those going on to Group 2s of patents next year, that you'll have some sound knowledge of patent law. I mean, it does become very complex, but that's not, that wasn't my duty, was to delve into those complexities, but to just ensure that you have a solid and sound foundation of patent law in South Africa, and also the practice that is followed in South Africa. As I mentioned, I am always available for any questions that you may have, so please do feel free to contact me either via email or to set up a meeting if you prefer. and I'll be happy to respond to that. Depending on how busy I am, it might take a bit of time, but I promise I will get back to you. And I wish everyone the best of luck in preparations for their exams. As I mentioned, we will have a question and answer session a week or two before the exam. So please do work through last year's examination paper, as well as the 2021 examination paper, where we can look at the questions that I'd asked, as well as what the expectation was in terms of answering those. But as I mentioned, I'm not going to be there giving the answers verbatim. I do expect that everyone does work through those papers beforehand and that we can have a collaborative approach during that session. Yes, and thank you very much to Andreas and Jerry for being the faces for these 2 days. I really do appreciate it. I feel like a complete idiot when I'm speaking to myself, so it really does help, and for all the engagement that everyone has shown in the participation, it's been most enjoyable. So yes, that's it from me. Thank you, everyone. As I said, I will post the recordings up onto YouTube, and I do apologize for missing the first 45 minutes this morning. Take care.
Thank you very much. Thank you.
Thanks, Marco.
Thanks.
Okay, bye.
Thank you, Marco.
Thanks, Marco. Thanks.
Pleasure. Bye-bye.